Take a nap.
I like saying it.
Welcome, everyone. Welcome to the Public Service Commission meeting of July 25th. We have the reading of the meeting minutes of July 11th. Does anyone wish to make any corrections or changes to the minutes? And if not, then we have a motion to approve the minutes.
Motion to approve the minutes of July 11th.
I second it.
Is there any discussion on the motion to approve the minutes of July 11th? Hearing none, all in favor signify by saying aye.
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 Are there any opposed or any abstentions? The motion carries. The consent agenda consists of 5 items today. Does any commissioner wish to have one of those items withdrawn from the consent agenda and put on the rest of the agenda?
Move we adopt the consent agenda as presented.
I second.
Any discussion on the motion to approve the consent agenda? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstention? Motion carries. Fourth item on the regular agenda is in the matter of the adoption of rules and procedures to implement the Renewable Energy Portfolio Standards Act. And we have Mr. Walsh to kick this off for us, please.
Thank you, Chair Winslow, members of the Commission. This is what has become known as Reg 56, a term near and dear to all our hearts at this point. We are here. We are here now on remand from the Superior Court. Now, by way of background, how we got there. As everyone is aware, that back in September 2010, the Commission had adopted 26 Delaware Administrative Code Section 308, which conformed with the cost-capped amendments to REPSA, the Renewable Energy Portfolio Act. And there were, after that, DENREC, 3 sets of rules that it promulgated, and a month prior to its 3rd set being promulgated on October 2nd, 2015, the Delaware Public Advocate filed a petition requesting that the Commission open a docket to consider whether to amend, I'll call it Section 3008, to issue regulations governing when a freeze of the minimum percentages of eligible energy resources, so solar photovoltaics, may be declared under Section 354I and J. And Cesar Rodney Institute joined in that petition, and this Commission denied that petition, and via Order 8807, the Public Advocate's Office then appealed to the Superior Court. Oral argument was heard for Judge LeGros, and Judge LeGros issued a memorandum of opinion on December 30th, 2016, remanding the matter and saying, in essence, what the Commission has done has essentially abdicated its statutory authority and obligations under Section 362 to issue these regulations and specify when and how freezing or lifting a freeze should take place. Thereafter, there were the February regulations, and since then, and why we're here today, we have the staff has revised those regulations considerably, and did so specifically in following the court's directive. And again, under 362, it is the authority of the Commission to issue those rules. We submitted a very lengthy memorandum outlining the bases for all the revisions to those regulations, and the fact that all comments from all parties were considered in those revisions. Those revisions are sound procedurally, substantively, and they certainly meet the hurdle of meeting the statutory authority, which is solely given to the Commission under 362, and the judge specifies that a number of times. So we would ask that the Commission, in reviewing the substantive and procedural outlining within the memorandum and in reviewing the revised, I believe it's referred to as instant regulations, approve an order for us to submit those to the registrar, and at which point the comment periods and any open meeting periods will, under that Administrative Procedures Act, then fall into place. But as far as where we are today, just to keep this simple and note where we are, the sole authority is right here to issue these regulations. We have done so, explained why we have done so, considered all other comments and suggestions, and have what is the best final compilation in meeting the court's directives on remand. And we would ask the Commission to adopt the order allowing that these regulations be submitted.
And publish.
Published.
Thank you, Mr. Walsh. Ms. Iori?
Thank you, Chairman and fellow Commissioners. I had heard through the grapevine that there would be no argument on the substance of the regulations today. I'm prepared to make an argument on the substance of the proposed regulations today. Obviously, it is up to the Commission if they want to hear it. But I became concerned by Mr. Walsh's reference to the regulations being procedurally and substantively sound.
Ms. Iori, can I just interrupt for a second? Just so you know, from my perspective, I'm assuming he's expressing what staff feels or believes to be the situation. From the Commission's perspective, there's a time for comments that's going to come up at a future date, and we'll be frankly very happy for all the parties to examine the veracity, but whether or not the substance is in fact, if the ruling has been followed. In other words, any substantive comment you want to make, we're going to hear. And I don't think, as you started off, I don't think today is the day for that, but I do understand, based upon Mr. Walsh's comments, why you expressed some concern. I just want you to know that as far as the Commission is concerned, this is just for publication of the proposed regulation, and we intend to listen to you, Mr. Myers, if he's going to be here, anybody else in the public, CRI, with respect to any issue that arises from this particular regulation.
Well, as long as it's understood that the Commission is not sanctioning these as the Commission's proposed orders. These are proposed regulations. These are staff's proposal.
Exactly. I agree. The staff's is not this Commission's.
All right. With that understanding, then we will reserve our argument on the substance of the regulations because, as I think you can imagine, we still have some problems with them.
No, I understand that.
Thank you.
Thank you, Ms. Iori. Ms. Scott, is she present to speak on behalf? Welcome, Ms. Scott.
Good afternoon. Deborah Scott, on behalf of DENREC.
Would you like to make any comments about the publication of these proposed rules and regulations?
DENREC intends to participate in the public comment period, provide written comments. If you want an update on the DENREC regulations that are in the process of being rescinded, I can certainly provide you an update with that. Secretary signed an order in July, and we expect to publish those rescinded regulations in the August 1st register.
Thank you, Ms. Scott. Is there anyone from the public that wishes to make any comment? Mr. Myers?
Good afternoon, Chairman and Commissioners. I just want to make sure I'm on the same page as everybody here. You're starting over?
Yes, sir. Basically.
So this order doesn't decide any of the substantive issues that we've raised before?
That's correct, sir. This is
So
just...
the Commission's will not, by publishing this order, take a position on those substantive issues?
No, as a matter of fact, there's no conclusions whatsoever made with respect to the comments made by Mr. Walsh. That's all the staff's position. They've done their homework. They've listened to everybody. That's the staff's position. The commission is going to wait and hear public comment and have thorough input and argument with respect to this matter before we make any final determination of what we think is best for this commission to rule.
I guess I'm just leery of, in effect, in September when we come back saying, well, we decided that on order so-and-so and so-and-so. I take it the commission and council is saying that's not going to happen.
That's correct, and the young lady over here is taking notes, as you well know. So you'll remind us, I'm sure. Plus, when you show up here in the fall, I know you're going to want to talk to us, and you're going to talk about what the issues you have. I know you have issues. By the way, while you're standing up there, this gentleman is the ex-retired Deputy Attorney General who worked for the Commission and who's spent many hours of his own time looking into issues that are of interest to him. I just want you to know that we do appreciate your input, and we do read what you write, and we do listen to you. So we're looking forward to listening to you on this issue after the publication, and we notify people for public comment.
I'm amazed that you're still awake if you read what I wrote.
I'm sorry, what did you say?
I don't understand.
The chair wins, let me add.
Yes, Mr. Walsh.
And if it makes Mr. Myers feel any better, I was still wide awake after reading what you wrote. And if I used words, maybe a matter of semantics, maybe a matter of having been in the law business too long, but what I stated should have been that we're following the procedures as outlined by the court on remand. This is what we're supposed to do. And substantively, when I said that the changes are substantively based or along those lines, I merely meant that in our memo, we substantiate why we did what we did. It was not. I was not speaking, putting any sort of dual rubric on the regulations as being procedural, substantive. One of the both, neither. It was just a matter of following the procedures outlined by the court. Why we're here procedurally, and the fact that we have substantiated. Probably a bad use of terms, but if that clarifies it for everybody, so be it.
Well, I don't believe that there was any implied criticism of your comments. I just think that there's a lot of people in this room who regard this as a very important docket, and they're very sensitive to all the issues involved, and they want to make sure, as good lawyers do, that the record's clear. I believe the record is clear. Any commissioners have any questions? Is there anybody else from the public besides Mr. Myers that wishes to speak? No one's coming forward. Any commissioners have any questions of any of the parties? May we please have a motion with respect to the application to have these regulations published, and also to make sure that there's public comment thereafter for the commission to consider these in final hearing.
Move we adopt order number 90.
Seconded.
Is there any discussion on the motion to approve the application? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion
Chair, I'd like to abstain on this motion.
Motion carries with one abstention. Okay, number 2 on the calendar is, and thank you, everyone. Mr. Myers, thank you. In the matter of the application of Comcast of Eastern Shore, LLC, commencement of proceedings regarding the renewal of the cable television franchise to serve certain unincorporated areas of Sussex County. Mr. Walsh.
Thank you, Chair Winslow. This docket, as you stated, Comcast of Eastern Shore, not to be mistaken with the other Comcast entities, is filed an application for renewal of its cable franchise. We have reviewed the application. It meets all the criteria set forth in U.S. Code, in addition to the Section 26 specifically of the Cable Communications Policy Act, and importantly, of course, the regulations under the Commission. And we believe that this is a properly filed application. It meets the criteria, and they have provided proof of the publication as required, and the publication. I should reiterate. This is the one that we had a couple. So this is the one that they're going to provide proof of publication on before August 25th of the next month, month from today. With that, we would ask that the Commission approve the order for the renewal of the franchise.
Thank you, Mr. Walsh. Is there anyone from the public here to make any comment on this matter? Did we receive any comments from the public on this, Mr. Walsh? Out of curiosity.
I don't believe so. If Ms. Knotts
is here.
I don't know that.
Commissioners, actually, this is just opening the docket for this order. So we have, as you'll see in the attachment, there's a public comments period that's going to be set up for written comments, as well as we typically have public comment sessions that occur at night. There's also an intervention period and everything that's all set up for that will be put in the newspapers for the public notice. So this is just the beginning of the process.
Thank you, Ms. Knotts. Any questions from anybody else? May we have a motion with respect to the approval of proposed order 9092?
Motion to approve order number 9092.
Seconded.
Is there any discussion on the motion to approve proposed order number 9092? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you, Mr. Walsh. This next is in the matter of the application of Comcast Cablevision of Newcastle County and the same issue. Mr. Walsh?
Yes, and
Same
I
speech?
beg your pardon and ask your indulgence on that. There were so many Comcast entities going through and different versions. It is largely the same scenario, except that there was an order in this one allowing for the hearing examiner to conduct evidentiary hearings, and they were in fact held on March 7th and 8th. And the DPA was attended, Delaware Energy Users Group, and this was I'm sorry, this is the prior. But this is not confusion here.
Okay, we're going to start over again,
May I
right?
defer to Ms. Knotts on this one?
Sorry, Mr. Walsh. I know that there was a lot of these franchise agreements, and we have one more that will be coming before you in the future. But this franchise, this application for the cable franchise renewal is for the Newcastle County unincorporated areas. And basically, again, this is only opening the docket to start the process for the franchise renewal and setting the public comment, the written comment periods. There is a hearing examiner, as Mr. Walsh has described, that hearing examiner basically acts to facilitate the public comment sessions that we have in the evening to make sure that we have ample public input on these. So again, this is just setting all the deadlines for public comment periods, intervention periods, and publication.
Thank you, Ms. Knotts. Mr. Walsh. Any questions, commissioners? Speaking from my perspective as a new Sussex County resident, people do talk about the availability of cable, and so I'm sort of anxious to see what sort of public input you get. Sometimes we're very disappointed on the type of public input we get, but hopefully we'll get some good input on this particular application. Anybody have any questions? I'm sorry. May we have a motion, please?
I move that we accept the order number 9093.
Second.
Is there any discussion on the motion to accept the proposed order number 9093? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you, Mr. Walsh and Ms. Knotts.
Thank you.
Number 4 on that is a matter of the application of Delmarva Power and Light for an increase in electric base rates and miscellaneous tariff changes. The commission welcomes Mr. Geddes. I think he's going to start this.
Thank you, Mr. Chairman, members of the commission. In thinking about this and coming down here, I'm reminded of a quote from one of my favorite heroes, Winston Churchill, almost 75 years ago. But paraphrasing it and flipping it, fortunately, this is the beginning of the end rather than the end of the beginning. Hopefully, this is the end. But like everything else in this case, it will not go into the night without one last little conflict. And I don't think they'll be thinking about this 75 years from now. Hopefully not. Anyway, we did have a...
I hope I am.
I'll be pushing up petunias, so you can do it by yourself. But we gathered on May 23 to discuss what staff had captioned a procedural exception. And as a result of that, the status quo, was before we got into the hearing room that there was a decision by the hearing examiner that basically said that if you agree to a settlement, then you agree to all the pre-filed testimony. When we left the room, that particular statement or finding had no more validity. The status quo had changed, and staff had at least prevailed going forward with regard to the idea that just by signing onto a settlement agreement, you don't necessarily stipulate to all the pre-filed testimony. As staff has done, at least, if the count is correct, over 9,000 times, and I remember here when the 9,000th order was entered, I thought that was pretty special, has written orders for your consideration. As you know, the Commission only acts by written decision. And what we have done historically is propose a written order for your consideration. But at the end of the day, it's your order. It's not staff's, it's not the DPA's, it's not the company's. And other parties, as a matter of privilege, not right, privilege, have the opportunity to comment. That privilege was started when I was Rate Counsel. It was started with Mr. Studley, then Mr. Clark. I don't know whether anyone remembers Mr. Clark. He was a great lawyer for the company.
I
really
remember him.
A great lawyer. Peter F. Clark, that's why he always introduced himself. And he would always say it was a privilege, and thank you for allowing us to comment. So staff wrote this order. We obviously reviewed the transcript, and we tried to capture what, in essence, the Commission said. Now, I will be the first one to say that in some cases, that's more an art form than in others. But I would say in this case, given that the issue was narrow, that it wasn't that hard to capture what the Commission was trying to say. And there were 2 points I believe you were trying to make. One, we don't want to decide this issue on this case because it's not an active case. It's been resolved, and going forward, I'm paraphrasing, there'll be another opportunity, maybe not, but if there is another opportunity, it'll be an active case. And we encourage the parties in that situation, hypothetical, to bring an interlocutory appeal so we can resolve it on an active case. And the second thing that you said was the hearing examiner's decision with regard to this exhibit should have no precedential effect going forward. Those were the two sort of quintessential points. They start on page 201 of the transcript, if anyone has it. And I think that's, in essence, what we were trying to capture in the order. Now, so we draft an order, we circulate it, we get changes back, we consider those changes, but in this particular, and Delmarva did not have any comments, so I don't think they really have a dog in this fight. We did get what I would call a rewrite back from the DPA. Their order doesn't look like our order. So let's just briefly go through this, and then it will be up to you as to whether you like staff's order, the DPA's order, or you don't like either one of them, or you decide to write one, or you ask us to amalgamate the two. Those are the options, but really only three options. So on the whereas clause on page 2, Ms. Arroyo suggests that the hearing examiner permitted witnesses for Delmarva. Well, I would suggest to you that that's not the hearing examiner's job. The hearing examiner's job is to collect the evidence and make recommendations. I don't believe his job is to permit evidence into the record. Obviously, if you have that right, you might have an evidentiary record with no evidence. Small point. Then, in the second whereas clause on page 2, she wants staff counsel objected. Well, there are many types of objections. You can have a hearsay objection. You can have a foundation objection. There are lots of objections. That's not what staff did. Staff specifically said, we are not going to stipulate this testimony. And if you look at our whereas clause, that's specifically what it says. We state what the issue is. We are not stipulating this testimony in. So I think it's more specific, and I think it's more consistent with what we did. Then, if you skip down to the 6 whereas clause, Ms. Arroyo, on behalf of her client, removes the word a procedural objection. Now, I found that quite curious, because if you look at your order in 1948, which was approved on May 23, it specifically says, whereas staff counsel filed a procedural exception. I mean, that's what we filed, and that's in your prior order, and that's what we put in this order, but apparently Ms. Arroyo found that was not appropriate. And then the last paragraph, I think it's stylistic, issues addressed in the hearing examiner's report. Well, I think that is did in the report, but in any event. The real substance, obviously, is in the ordering paragraph. And I'm not sure why this introduction of Mr. Gorman's pre-filed testimony through DPA witness is so important. Clearly, our problem was with the marking of Mr. Gorman's testimony as an exhibit in the proceeding. But why I think our first paragraph is better is because we state the issue again. And I think the issue is important to have stated. Namely, that an uncontested settlement negates all settling parties' rights regarding the stipulation of pre-filed testimony into the record. That was the point we were trying to make. And it's in the first ordering paragraph, and it basically says that on this record, which is what you said, pages 201 through 205, is we don't want to decide this issue on this record. So we said on the record presented, and here's the issue. And so I think that's appropriate. And then the second paragraph doesn't have any precedential value in future commission decisions. That's exactly what you said. And specifically, the references, Chair Winslow, page 205. We want to address the issue the first time it comes up, and there's an objection, and resolve it on the record. So I think it captures that. And the third paragraph, you could use are or there. Obviously, how many angels can dance on the head of a pin? But the first two paragraphs are the substance one. And all staff has tried to do is capture what you said. And I think we've done it in a fair way. It has been reviewed by internal staff, including internal counsel. And I think it is, in essence, what you decided. And my objection is more a procedural one is, yes, we do allow the privilege to comment on these, but this is a different order. Ms. Arroyo is going to tell you why she thinks hers is better. But at the end of the day, it's your order. It's not ours. We think we've done our job, and we present it for your favorable consideration.
Thank you, Mr. Geddes. Ms. Iori?
Thank you, Chairman. Commissioners. Well, we obviously disagree with the order. I do appreciate that we have had the opportunity that it was circulated before being presented. But I can tell you that even if we did not have that privilege of reviewing it this year, we would be objecting to it anyway. As Mr. Geddes said, it isn't staff's order, it's not the EPA's order, it is your order. And we disagree that the order reflects what the commission did. Now, the reason that I wasn't going to go through, because I think the meat of this is really in the ordering paragraphs, but Mr. Geddes went through the various other ones, so I will too. Where it says the hearing examiner permitted witnesses for Delmarva, the EPA, and the commission staff to adopt the pre-filed testimony. That is exactly what he did. And then staff objected to it. Staff had told the hearing examiner before we started hearing any witnesses, that he would not stipulate to Mr. Gorman's pre-filed testimony being admitted. The hearing examiner said, fine, we'll get to it when we get to the witnesses. So that is what happened in the hearing. We put the witness on. And then when I took Mr. Watkins through his direct examination, adopting his own pre-filed testimony, to which obviously there was no objection. And then when I asked Mr. Watkins to whether he had reviewed Mr. Gorman's testimony, whether he would adopt it as his own, Mr. Geddes objected. And the hearing examiner overruled that objection. So I think it is accurate to say that the hearing examiner permitted witnesses from those parties. But if Mr. Geddes has a problem with that, it's not a big deal, nor is objected to. I think it's semantics in this case, but what I just described to you is what happened at the hearing. I don't know, if he wants to put procedural exception back in, fine. I'm not going to die in the ditch over that. But what I will die in the ditch over.
Hopefully not.
Well, Andrea would be happy she'd get the Mustang. Is the two ordering paragraphs. We think the issue is important too, and we don't think the issue is the way staff framed it, which is why we changed it to what we believe. Now, Mr. Geddes told you page this of the transcript and page that of the transcript. Let me read to you. And this was in a response to a question from Commissioner Correa. Mr. Geddes responded.
What page, please?
I'm getting there, please. 198. I'm sorry, 197. Back that up. Line 15 starts Mr. Geddes' answer to Commissioner Correa's question. Well, let me add, I think there are two questions in that. The first one is that by not doing anything, you would adopt the hearing examiner's report, which has the reasoning, which staff is accepting to. So I am not sure that is a viable option to the extent that you're concerned about it. Going forward, you can always change your position, but you have to then articulate, consistent with the Chesapeake decision, the reasons why you are changing your position on this particular issue. Probably the preferred method as an alternative is to strike the issue and not have the issue per se resolved because it wasn't spoken to, even though people will go back and argue that the transcript is the decision. But the fact is that the commission did not include it, but the fact that the commission did not include it in the hearing examiner's report would be better than nothing, not preferred, but as a way to do it. But by not doing anything, then the hearing examiner's decision would have some precedential value going forward. Now, after that exchange, Chair Winslow asked the parties what they would say if you made a motion to remove the hearing examiner's reasons in footnote 6 for overruling staff's objection from the report that the commission had already adopted, and directing that in the event this issue arose in another case, to bring it to the commission's attention so that it could make a decision on the merits of that particular case. You then added to your motion that the hearing examiner's decision on the issue would have no precedential value. Commissioner Drexler seconded that motion. On pages 205 and 06, Commissioners Gray and Drexler indicated their assent for the motion, and when it was called for a vote, the commissioners present voted unanimously for it. So while there was a lot of questioning and various commissioners making comments, at the end of the day, what the commission voted was to remove footnote 6, state that the hearing examiner's report would not be cited as precedent on the issue at any future proceeding, and direct that if the issue arose again, to bring it to the commission's attention as soon as possible so that it could be decided in an active case. So the DPA's revisions to the proposed order reflect what the commission actually voted for. Staff's proposal in paragraph 1 says that the commission does not affirm the hearing examiner's ruling on the evidentiary issue presented by staff's exceptions. That suggests that the commission substantively rejected the hearing examiner's decision, but it did not. It did not address whether the hearing examiner ruled correctly or not, although that was what staff wanted you to do. That is why I read you what Mr. Geddes said in response to Commissioner Correa's question. The commission did not make a substantive decision that it did not affirm the hearing examiner's ruling on the evidentiary issue. It voted to remove the footnote so that it was never in the hearing examiner's report. So, with that, now ordering paragraph 2 of Order 9048, which the Commission adopted on May 23rd, 2017, states that the Commission ordered that the hearing examiner's report and recommendations are hereby adopted. Now, that report and recommendations included footnote 6. So we believe that it is necessary for the order to reflect that Order number 9083 amends Order number 9048 to the extent that it removes footnote 6. And so we added language that this order was amending that order to that limited extent. The DPA believes that it is important for the order to reflect what the Commission actually did and not what staff wanted it to do, because the Commission did not make a substantive decision on the hearing examiner's. Thank you.
Thank you, Ms. Iori. Mr.
Yeah, just if I might.
Steve, please.
Just a short comment. I'm not sure that, citing what I said to the commission is representative of what the commission actually does. I'm just the lawyer. And her argument with regard to paragraph 1 seems to be that, well, I said this and I said that. Well, that's just lawyer's argument. I do think, the analysis of what Commissioner Correa said and what you said and Commissioner Drexler are important in resolving this in terms of what actually was done. But if you look at our ordering paragraph, the record presented does not, you do not affirm the hearing examiner's decision. That's in essence what you did. Whether you take the footnote out or not, you're in essence saying, we're not going to deal with this. And we wrote the order in such a way, the second paragraph, the last whereas clause, specifically says that you approve the rates in the prior order and placing new rates into effect beginning, and that was an addition Ms. Iori made, and we accepted it on June 14th, and now resolves staff's exceptions. Now, in essence, what it is, it's supplementing the other one. Say, that was not addressed before. Now we're supplementing, we are addressing this issue here. So, I do think it's tilting at windmills, whether you drop the footnote, excise the footnote, or basically say, look, this order is clear. The hearing examiner's report has no precedential value going forward, period. And that's all you're saying. And you want a new record to decide it. I think that accomplishes it, but you've heard the argument. So,
may I respond briefly?
1 second, please.
If that is all that it does, then you don't need to drop footnote 6, and you don't need ordering paragraph 1.
What I would suggest is the following. We'll hear from you. you can make your comments, and perhaps we can together come up with something if either one of these are not acceptable to you.
Any commissioners have any questions?
Yes, Mr. Chair, I do.
Mr. Gray.
What is inconsistent about saying that the commission on the record presented here does not affirm, et cetera, according to counsel, and summarizing that paragraph with, we adopted the hearing examiner's report to strike from the report footnote 6 on page 10. What is inconsistent about saying both?
Nothing. We could join the two.
Mr. Geddes, am I hearing from you that if you had a few minutes to talk with Ms. Iori, this matter might be resolved between the parties? Because we have other items on the calendar, and I don't want to go off on a fruitless chase to get something resolved, but I mean, if you think there's a possibility that, she made some good arguments, I think. And of course you did as well.
I think if there's more guidance that the commission wants to give us on the comments you've heard, such as Commissioner Gray's, that would be helpful. I do not suggest that we try to do it, waiting, trying to get it done today. I'm sure we can get through it, but we need a little guidance here. I think I've done my job. Gina suggests I haven't. So Commissioner Gray's temporary solution, or at least one solution, was to try to amalgamate the two. I'm amenable to that. If you have any other comments, she also doesn't like paragraph 2. I think you've addressed paragraph 1. Do you have any comments on paragraph 2? Ours says has no precedential value, and hers says shall not be cited as precedent. I think if it's the will of the commission, I'm speculating now, you have to tell us, to put those two paragraphs together somehow.
It's the same thing. To me, those two paragraphs are
Well, but that's the point. It's
redundant.
that.
But one, okay, I see that there's a little bit of difference between paragraph 1 here, paragraph 1 here, and combining them, as Commissioner Gray has said, would make some sense. But to me, it's just rewriting the same paragraph in a different way. That's my opinion. So
I would agree with that.
really focus if there's any change on 1, and then on 3. Ms. Iori has changed some wording in 3 that says immediately to our instead of their. I mean, in true English form, it should say its, but I would
Option
accept
3.
our over our.
I would agree there is not the right word.
Yeah.
I would agree with that.
Our is better than there, but its is better than both. So those were the changes, but 2 is just saying the same thing. I would focus on if there are going to be any changes on paragraph 1.
Not to be flippant, perhaps the commission would like to draft this for us.
Well, let me ask, if I might, Commissioner. Okay. I guess my sense is, if there are truly conflicting points of view being articulated here, zone in on what those are of conflict. But where there's synergy and complementary statements being made, can't we, as the chair has suggested, come together and try and reconcile that everyone's ideas are captured at the end of the day?
I think that is an excellent idea. The only caveat I would suggest, unless other commissioners have comments, is that we not try to wordsmith it in the back room. I never find that to work out too well, because sometimes you don't, it's easier to take it away, wordsmith it, and bring it back to you.
I have no objection to that.
Good suggestion. I think basically we're together, it sounds like to me, so I think it's a good opportunity for you guys to finalize it. And we'll have a better work product based upon both staff and DPA's efforts, which will be appreciated. So we will then put this on the docket for the next meeting, which is in August. Next matter, number 5, is in the matter of Delmarva Power and Light Company for a change to its transmission service charge for its electric supply and transmission customers. Ms. Scott, welcome.
May I proceed, Chairman?
Yes, please.
Thank you. Before you is in order to approve Delmarva's application to revise the transmission service charge for SOS fixed price service and SOS hourly price service. Essentially, this is a pass-through rate for Delmarva's retail customers. It's based on a formula rate that is established pursuant to a FERC settlement. The order proposes to approve the rate as filed by Delmarva. We've reviewed the order and have no issues with it and ask that you approve it.
Thank you, Ms. Scott. Mr. Walsh?
Thank you, Chair Winslow. We have reviewed this, and given the fine tunings of it and the math behind it, if the Commission is okay and the Chair is okay, I would ask that Mr. Farber be allowed to speak as to the proprieties of the increase and the request, particularly given the dual FERC and Commission implications here.
First of all, I want to comment. I think this is the best coordination of clothing I've seen between a lawyer and a client in a long time.
We had just commented
Really?
on that ourselves.
Of course, Mr. Farber's known for his haberdashery. Mr. Farber.
Thank you, Chairman Winslow, Commissioners. This docket was opened with the company's filing of its update to its retail transmission rate, which, as described in the memo and as summarized by Ms. Scott, is basically controlled at the Federal Energy Regulatory Commission, or FERC. Issues concerning the cost inputs or other implications to the formula rate, which derived the network rate that would be applied here, must be addressed at the FERC. And so on that basis, staff is recommending that the rate be approved as final and that this docket be closed once the company files tariffs in compliance with the order that reflect the revised rate.
Thank you, Mr. Farber. Ms. Iori.
Thank you, Chair Winslow. Staff's memo states that it would suggest further discussion with the company to determine whether there is a way for staff to obtain the information necessary to complete a bill impact analysis on the basis of the relationship between kilowatt hour consumption and corresponding PLC demand. And we would just ask to be included in any further discussions on that and to be provided with the same information that staff obtains.
Ms. Scott? Any comment on that comment?
No, Your Honor, no comment.
Does that mean yes or no?
We have provided pretty much as much information at this point as we can with respect to what staff was looking for in terms of the customer impact.
Are we avoiding the future for some reason?
No, we are not, Your Honor.
So in the future, I mean, was that a reasonable request for DPA, or do you want to just leave it with the information with the staff to then, could I guess, share it with DPA?
Well, the only reason we brought it up was because it was in staff's memorandum.
Right. I mean, I can certainly forward to you what we responded to in discovery. But we don't have any really additional information at this point that we can make available beyond what we have.
Have you entered your appearance on this matter?
Not yet, because it's not yet, no.
Okay, well, enter your appearance, and then I'm sure that Delmarva Power and Light will provide you with all the applicable information pursuant to our rules and regulations.
I don't mean to be contrary, although I am a very contrary person.
Contrary statement.
But under our enabling statute, we are permitted to receive any information that the staff gets from the utility, and we don't need to enter in our appearance to do that.
Well, I'm sure staff will give it to you then.
Okay, we'll get it from staff then.
But we'd love it if you would enter your appearance so you can be a full-fledged member of
Well,
this.
the case is over. There's kind of like not much
Oh,
sense
that's
in
true.
doing that.
That's true. Any commissioners have any questions?
Just a short follow-up on this question about the rate impact to customers. Is it my understanding now that, Mr. Farber, staff will quantify in some way what this impact to the average customer is going to look like? That's not my understanding.
Well, Commissioner Gray, ultimately, there's kind of a miscommunication between the company and staff in terms of what's necessary to establish the impact of the change in the transmission rate, which is on a per kW basis, on customers of various consumption levels. The company can't provide the information. I mean, I put that in the memo so that if the occasion arises, I may try and pursue further what's necessary in order to do what staff would view as the impact on kilowatt-hour consumption as a result of a change in a kW demand rate. At this point, that information is not available, but perhaps in further discussions, maybe something can be provided, but at this point, it's not available.
Ms. Scott.
Commissioner Gray, the impact has been quantified in terms of it's a rate increase of approximately 8.8%.
Right, I got that. But I guess I'm trying to determine in my mind, is it that you have parameters, there's a gradient of rates depending on the size of the kilowatt demand, and then there are differences in usage by customer that means that you now have a very dynamic challenge to come down to what might be considered an average impact?
There would be a significant amount of work and a significant amount of data involved to get down to the very fine granular detail that Mr. Farber seems to want in this case.
Okay, understood. Thank you.
And we have a motion on the application.
Move we adopt Order 9091.
I'll second it.
Is there any further discussion on the motion to approve proposed order number 9091? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you, Ms. Scott.
Thank you, Commissioner.
Mr. Walsh, Mr. Farber. Number 6 is in the matter of the application of Tidewater Environmental Services, Certificate of Public Convenience and Necessity to provide wastewater services. Welcome, Ms. Higgins.
Good afternoon, Chair Winslow and Commissioners. Would you like me to kick this one off?
Yes, please.
Okay. This is an application for a CPCN for wastewater for one parcel of land, 0.95 acres, just outside of our territory in the town of Milton. This was an outlier that was not transferred at the time that we acquired the town of Milton's wastewater system, and the owners have requested a timely service. They're going to build a house, or the house is being built, and they want, I think, service within the middle of next month. So this was just a CPCN request to waive some of the timing requirements.
Mr. Walsh?
Mr. Chair Winslow, we reviewed the application. It meets the requirements, Section 203D, providing the tax parcel, the affected land, tax parcel, IDing the owners, also a CPCN signed by all landowners of record, or I should say landowner of record in this particular instance, and as well as the commission-approved notice sent via certified mail. And as you're aware, under 26 Administrative Code 6001, there is the ability to waive the timing requirements where cause is shown, and I believe the cause is appropriate here given the timing of the family needing to move in, I assume, prior to the school year beginning. Seems like good enough cause. The DENREC was noticed, as well as the county, and they replied that they were okay with the application as well. So we are okay with the CPCN application.
Thank you, Mr. Walsh. Any questions?
Move we adopt order number 9096.
Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion carries. Thank you, Ms. Higgins. Number 7 is in the matter of a technical review conference of potential rate designs for consideration by regulated utilities and electric suppliers. Mr. Geddes.
Mr. Chairman. Thank you. Mr. Chairman, members of the Commission, this is staff's petition, and I would say that it is what we call a talking petition in the sense of it gives you the context or perspective on the history of discussions with regard to rate design issues. The relief is pretty specific. In the wherefore clause, page 6, it specifically asks the Commission to consider opening a new docket to provide for a review conference, just a conference to study new approaches that could be beneficial to both utility customers and service providers and determine if there should be any changes. It doesn't mean that there will be any changes. It's merely a study conference, if you will. So participation is asked of all the utilities, but there's no requirement that the utilities specifically participate. I would assume some would want to and perhaps some would not. The order specifically itself does provide that the docket would be open and that a technical review of these various rate designs be held, whether it be several meetings undetermined, but that staff would arrange for such conferences in Wilmington, and hopefully we'll get some insight as to whether there should be any changes in rate design. This has been discussed for a long time in various contexts with various utilities, and this is just an attempt to capture those discussions in an attempt to see if any changes should be made. So staff would respectfully request that you enter the order that's set forth on the docket as 9094.
Thank you,
staff
Mr.
drafted.
Thank you. Thank you, Mr. Geddes. Ms. Iori.
Thank you, Chairman, Commissioners. Mr. Slater and I are going to tag team this one. I'm going to start off providing you with a little more history than is included in the petition, and then Mr. Slater will take over. So, GPA is being very contrary today, but we don't think this proceeding is necessary. We think it's a solution in search of a problem. And because we have new commissioners, I do want to go through some of the history of utilities requesting alternative rate designs. And we'll start with Delmarva. In docket 09414, Delmarva requested a decoupled rate design and proposed a bill stabilization adjustment. Now, the decoupling request came about because Delaware law at the time required all electric and natural gas utilities to adopt a decoupled rate design by the end of 2010. That law was repealed during the pendency of docket 09414. But nevertheless, the parties in that docket actually entered into a settlement agreement that would have implemented a modified decoupled rate design, but the Commission rejected that settlement. And Delmarva may have gotten a bill stabilization adjustment similar to what it had in Maryland if it had been willing to reduce its return on equity to account for the reduction in the risk, but it didn't want to do that. In docket 11528, Delmarva submitted pre-filed testimony discussing various types of rate designs, including forward-looking rate plans, a reliability investment tracker, and a fully forecasted test period. That case settled unanimously without any rate design changes. However, in the settlement, the parties agreed to look at a forward-looking rate plan, and in 2013, a docket was open to consider a forward-looking rate plan. During that proceeding, there was a lot of debate among the participants about the information that had been provided to support and justify the proposed plan, and it didn't go anywhere. And that docket was ultimately closed as a condition of the PHI Exelon merger docket settlement agreement. In its last rate case, Delmarva didn't ask for any alternative rate designs, but it did go to the legislature this year to try to get a DSIC, and that didn't go anywhere this year either. On the natural gas side, in Delmarva's most recent gas base rate case, which settled, Delmarva agreed to perform a study of declining block rates. Right now, the Delmarva's gas rates are not declining block. Are not inclining block. And I think I meant to say agreed to perform a study at inclining block rates. Now, in its most recent application for an increase in natural gas base rates, Chesapeake proposed a revenue normalization mechanism, which is a form of decoupling. In that case, staff's own rate design consultant opposed Chesapeake's requested revenue normalization mechanism, and one of the reasons he did so was because of the Commission statement in docket number 07-28, Order 7420, that surcharges for revenue deficiencies related to conservation efforts are not the preferred approach. The DPA also opposed the proposal and suggested consideration of a weather normalization adjustment similar to what Virginia Natural Gas has. That case also settled, and there was no alternative rate design in the settlement in that case. But in the settlement, among other things, Chesapeake agreed to study the effects of phasing out its declining block rates as part of its next base rate case. Now, some years back, Artesian requested an elasticity adjustment. That case settled without such an adjustment being approved. It doesn't appear that Tidewater or Sussex Shores have ever proposed alternative rate designs. Suez requested a revenue and production cost adjustment mechanism related to usage levels at its Delaware City refinery in its 2010 case, but that was related to the then closure of the facility. That case also settled without agreement to such an adjustment, and in its most recent base rate case, Suez did not propose any alternative rate design methods. So I think based on that, it's fair to say that rate design has been an important part of most Class A regulated utilities rate cases. And those utilities have agreed to settle a lot of those cases without securing an alternative rate design. They've apparently determined that the settlement will provide them with the revenue they need to continue to provide safe, efficient, reliable service. And if the Commission rejected their requested rate design, as happened in the one Delmarva case with decoupling, they have options: propose something else or try to get the law changed. So the DPA asks that, given all of that, why is this docket necessary?
Staff says in this petition that another reason for opening this docket is that utilities are facing declining usage, but there's been no indication that they have been unable to provide safe, effective, and reliable service without the alternative rate designs they have proposed. And as this discussion has shown, parties to rate cases are perfectly capable of requesting alternative rate designs to address that issue in the context where the other parties in the case can examine the claim to determine whether the utility really needs that requested rate relief. We believe that a rate case is the appropriate venue to examine rate design proposals for a utility for that very reason. In a technical conference, the discussion will necessarily be more general because there's no particular proposal on the table, and participants will not be able to examine any data supporting or negating a particular proposal. Next, all of the rate designs that staff indicates, dynamic pricing, fixed volumetric increased block rates, critical peak pricing, have already been considered in rate cases or other dockets. The Commission's already authorized dynamic pricing and direct load control. In fact, ratepayers are paying millions upon millions of dollars for the those programs. The direct load control program has cost ratepayers $22.7 million, according to Delmarva's quarterly performance report for the third quarter of 2016, which is the last quarterly report on the Commission's docket that reported program totals. I wasn't able to find anything indicating how much Delmarva spent on dynamic pricing exception, but according to its filing in its most recent electric distribution rate case, that regulatory asset balance of $10.28 million for the dynamic pricing. It's been amortized regulatory assets for several years, however, so the actual costs have exceeded the $10.28 million. The DPA acknowledges that Delmarva has received some remuneration from PJM that's been used to offset these program costs, but the amounts received from PJM have not offset the cost of these programs. And with the changes PJM has proposed with respect to bidding demand response into its auctions, it's likely that Delmarva will receive even less from the capacity auctions. In fact, it can't even bid into the capacity auctions anymore, as was the case in the previous auction. With respect to inclining block rates, a review of Delaware's Class A Regulated utility tariff shows that most of them already have inclining block rates for residential customers. The natural gas utilities don't, but as discussed previously, they have agreed to look at the issue. Apparently, Delmarva does not have inclining block rates for residential space heating customers. And as staff states, the DPA and Delmarva spent the better part of a year talking about staff's idea to implement a demand charge for residential small commercial customers. Ostensibly, the reason for these meetings was because of the negative effect of net metering on Delmarva's revenues. Under current law, net metering customers can zero out their entire bill, including distribution charges, and carry credits over from month to month. That's in 26 Delaware Code, Section 1014E. So the DPA is sympathetic to the argument that net metering is having a detrimental effect on Delmarva because net metering customers can wind up contributing nothing to the meetings and replacing their distribution facilities that they use to transmit their electric supply to Delmarva. The DPA doesn't agree with demand charges for residential and small commercial customers and didn't agree with them during those meetings, but that's really not the point here. If net metering is the problem, then why not exercise the authority the General Assembly has given the Commission with respect to net metering? 26 Delaware Code Section 1014F specifically states that the Commission shall periodically review the impact of net metering rules in this section and recommend changes or adjustments necessary for the economic health of utilities. The Commission hasn't reviewed the impact of net metering since the bill was passed and signed into law on July 24th, 2007, which was 10 years ago to the day yesterday.
Please slow down, Mr. Smith.
Sure.
And can you provide a copy?
Yes.
Sure. Why not open a docket to examine the impact of net metering? With respect to other states that have adopted alternative rate designs, the staff petition says nothing about whether those states' laws permit them to adopt such rate designs. In Delaware, however, the General Assembly has specifically forbidden electric distribution companies to implement peak time billing in 26 Delaware Code, Section 1008B1. And if this has been expressly forbidden, AMI to be deployed in a manner that permits 30-day peak demand billing except as approved by the General Assembly. That's in 26 Delaware Code Section 1008B1B. Demand charges are based on customers' peak demand, so it's questionable whether the Commission can even order an alternative rate design for residential and small commercial customers based on a customer's peak demand without specific approval from the General Assembly. Moreover, there are other ways to address the issues that staff perceives requiring this docket. The Commission could amend its regulations to allow utilities to file rate cases using a fully forecasted test period. Staff doesn't like that proposal, but it is an option and one that Delmarva has proposed previously. 26 Delaware Code Section 304B gives utilities the statutory right to file limited issue rate cases. Staff hasn't preferred that approach either, but it's an option that the General Assembly has specifically approved. Prepaid electricity could provide Delmarva with a better revenue stream. The settlement in the most recent electric case provides that Delmarva staff and the DPA will convene a working group to address prepay. That hasn't happened yet, even though the settlement was 6 months ago. Staff discusses proceedings in Maryland, Pennsylvania, and the District of Columbia, but there's no indication that their legislators have imposed the limitations that Delaware's General Assembly has. So the DPA considers the existence of those proceedings to be of limited value. Finally, I have to question if this workshop will be limited to what staff's executive director and DPL have already been working on, as was mentioned and is in the transcript of the June 6th Commission meeting. This petition is under a generic heading, and no issue has been identified that needs to be quote-unquote fixed. As has been my experience, staff's going to set the dates, and then we'll have to scramble to try and meet those dates, as was the case last week. We should try to remove the veil of secrecy around staff's position and first know what issue staff is trying to fix. Or are we just trying to satisfy the conversations behind closed doors that we know have already occurred from the June 6th meeting from Delmarva Power? For all these reasons, the DPA does not believe that the Commission needs to open a docket to study rate designs. Again, this petition is a solution in search of a problem. In summary, the DPA does not believe this proceeding is necessary. Rate design proposals specific to a utility can be proposed and debated in a utility's rate cases where discovery is available to investigate the utility's claims. This proceeding will do nothing but increase the regulatory costs that ratepayers have to pay for all regulated utilities, and will take both the Commission staff and DPA staff away from other responsibilities, such as the rate cases that Delmarva plans to file in August. and the working groups on prepay and jurisdictional rate allocation that the settling parties agreed to in the settlement of docket 160649. The DPA appreciates the Commission's consideration of their opposition to this petition and respectfully requests the Commission to deny it. Thank you.
Thank you, Mr. Slater. Mr. Goodman?
Thank you, Chair Winslow. I'll start out with good news. I didn't come with a prepared statement such as you just heard to read. Mine's a little briefer, but I would like to first thank staff for being proactive here and looking into these important issues. If you look around the country, I think you will find probably the majority of states have adopted some form of alternative rate design to take advantage of customers' needs, new technology available, and my staff has been wanting to do this for some time, has brought it up for some time, and I think they're doing the right thing. And we support looking into these rate designs very much. I speak, of course, for Delmarva Power's electric and natural gas. I do not know what the situation is with regard to water companies. I just know it's different. So I do not speak on behalf of all utilities. I speak on behalf of Delmarva. We have brought to you first the bill stabilization adjustment. I think you and Commissioner Kano are probably the only two that were here for that. Contrary to what Ms. Iori said, it didn't go away because of an issue regarding ROE. Actually, staff progressively said, we think we can do a better decoupling method, and you too will remember this one. I'm surprised I actually did, but it was called the Modified Fixed Variable Rate Design. And we were all moving forward in support of that, staff, the company, and when we were at the final oral argument in that rate case, I think you'll remember a bus of about 40 folks who at the time were called the 912 Patriots showed up, and that's what stopped that. So it had nothing to do, the demise of BSA had nothing to do with ROE, and we were never close to getting anywhere near getting what they have in Maryland, which is the BSA. That's just an important correction, and I wanted to point out that staff has supported alternative rate design for quite some time. There was comments that I think I want to correct here about $10.28 million for dynamic pricing. We have received, and if you need the numbers, I'll get them for you, millions and millions of dollars that we have returned to our customers through the PJM capacity market. And there was a statement from DPA that there will be no more capacity revenues in the future. That's technically true, but as you know from our presentations here before this commission and from a letter that was provided maybe a month ago, Delmarva and its affiliate utility, BG&E, were the only two utilities in PJM to move forward and try and get additional PJM revenues for its customers through dynamic pricing and direct load control, and we informed you that we were successful. We were the only two utilities, and we sought both performance. I got to get this right here because we bid into the price responsive demand market and also a market where we could join our winter programs with summer programs, and we received several $1 million for our customers. So there will be benefits as a result of dynamic pricing and direct load control going forward beyond the 2020. That's a fact. That's accurate. So to say there'll be none going forward, this isn't correct. And then I will just point out one other thing. We heard from Mr. Slater several comments about the code suggesting it doesn't allow for this type of looking at alternative rate designs. And while I don't have the site in front of me, I'd be very glad to provide it to you, but I will state that the Delaware Code specifically grants this commission the ability to adopt alternative rate designs in plain English. So we support this 100%. We commend staff for looking into it.
Thank you, Mr. Goodman. Is there anybody else from any other utility present that wishes to speak on this matter? I see no one coming forward. Commissioners, any questions?
Rejoined, or do you want to hear comments or not?
You want to say something in opposition to Ms. Iwari?
That would be novel. Could I just
brief, please?
Yes, please. I do think from the discussion that the DPA has put before you on their comments, all those issues were raised in individual rate cases where the pressure to try to get the monetary issues resolved to the bottom line and in rates sometimes drives resolution of those issues. I can remember a long time ago in the 80s where rate design cases were filed as companion cases with revenue cases so that they were separated out and were not subject to the same pressures. This is an attempt to bring this issue out, alternative rate design, outside of a context of a rate case, and to do it generically, and to bring it outside the what DPA referred to, behind secret doors or whatever. It's to have a discussion about whether any of these designs are appropriate, looking at other states. And at the end of it, you may decide, because of legislative restrictions and or other restrictions, not to do anything. Or you may decide that we need additional legislation to do something. But it will give you an opportunity to hear whether there should, whether alternative rate designs that are being adopted around the country, whether any of them are appropriate for the utilities in Delaware. If you don't have this proceeding, you cannot reach that conclusion, either positive or negative. Thank you.
Commissioner Correa?
On page number 1 of this order, the last line, it says informal technical review conference. To me, this sounds like a poetry, and I'm all for that. Because keeping an open mind for the things that are changing, not only in our state, but all other states, we can bring everything, pull everything together, and hear something good. And if we like it, we will go for that. And if we do not agree or so, we will tell you so in plain English, not poetic one, but simple English, and tell you so. So I like the idea and presentation. I hear you with the litany of all the cases for last 10, 15 years also, but keeping an open mind will be a good thing for the commission at this time. So I like the concept.
From my perspective, I'm going to look at it in a positive way. Appreciate the comments by the public advocate, but it seems to me it's high time that the commission looked at some of the things that are going on in the rest of the country that might be beneficial to our consumers. And so I would look at it in a positive way to say, well, let's try to find out what's out there that might be helpful to us. So I'm supportive of staff's efforts.
Mr. Chair?
Yes, ma'am.
I would agree wholeheartedly with all of the changes that are occurring in this world in usage, especially with the introduction of all kinds of green energy. I think we need desperately to look at what has gone before, what may be coming. I don't want to be caught short with the utilities needing some source of new rates, and the way that everything is changing, we desperately need to look at this. Whether anything occurs or not, at the very end, we still need to investigate it.
Mr. Chair?
Yes, sir.
I tend to agree with my fellow commissioners. Why not provide the commission some benchmarked options? This is a dynamic industry, and I hate to say that it appears from my perspective that all of the utilities that are regulated by us are riding one-horse pony, which is volume. And if efficiencies and volumes then are driven down, what becomes the alternative? So we don't have the bandwidth, I think, to look to every other example of who has solved a problem that we may be confronted with in the near term. So I think it's a good idea. Devil's always in the details. A couple of questions I would raise is who pays for this? And then how do you maintain the scope of this? Because one rate case is a substantial undertaking. And if you're thinking a technical conference around rates from multiple industry sectors and utilities, it sounds like a fairly big chunk to try and bite off and digest. So I'd only be a little concerned about how much volume of information and material we can digest, how long will it take, and how much will it cost. So.
Move that we adopt order number 9094.
I second it.
Is there any further discussion on the motion to approve order number 9094? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes. Thank you all. There's nothing on the hearing schedule. Is there anyone here from the public that wishes to make any comment to the Public Service Commission? Is Mr. Noyes here today? Does he or anyone from DENREC want to make any comments? He doesn't appear to be present today.
He
was here earlier. I thought I saw him.
With Deborah Scott.
Yeah. Mr. Howlett?
Chairman Winslow, Commissioners, good afternoon. Once again, we have some enjoyable information to share with you. And I would ask Mr. Joe DeLosa to come up and talk with you about some financial transmission rights appeal that has gone forward.
Good afternoon, Chair and Commissioners. I'm not sure how enjoyable this is, but I'll try to make it quick. So, the purpose. All right.
There it is. There it is. Okay.
Well, that's enjoyable. So, the purpose of me coming before you today is just to provide you with an update regarding the Commission and its participation in an appeal to the D.C. Circuit regarding FERC's order on FTRs. So, I'll start by going through some dates. October 19, 2015, PJM originally filed with the Commission seeking to change some elements of its FTR market. The FERC set a technical conference to discuss the filing last February 4, 2016. Commission issued its first order. The Federal Energy Regulatory Commission issued its first order on September 15, 2016. The next month, on October 14th, this commission and the New Jersey Board of Public Utilities together requested rehearing of that September 15 order. This past January 31st, FERC rejected all rehearing requests, including ours and New Jersey's. This past March 28th, you'll recall Mr. Hartigan stepped in for me, requesting that the Commission approve staff's pursuing of an appeal in this matter. Briefly, just by way of review, before the original FERC order, staff's view is that the FTR market is generally broken, depriving Delmarva Zone customers of approximately $7 million a year. After the September 15th order, that number will have grown to about $11 million, give or take. It's very hard to estimate. The appeal that you approved on March 28th included us, the Delaware PSC, the New Jersey Board of Public Utilities, the Independent Market Monitor for PJM, Old Dominion Electric Cooperative, which is the parent company of Delaware Electric Co-op, and American Municipal Power. On July 11th, this month, we filed our initial brief together with all the other petitioners. Staff felt that the most important single issue in this case was that the brief attacked FERC's order from the perspective of returning all congestion revenue to load, not returning back to the previously broken FTR market, but rather returning all congestion revenue to load. And I'm happy to report that through conversations with the petitioners, that is the direction that the initial brief went in. I'll just give you a quick outline of the brief. There were three main sections. The first is balancing congestion and the assignment of that particular element of congestion. This was the largest part of our brief. We petitioners together felt it was FERC's most egregious error in reasoning, and so we spent most of our time in the brief on this issue because we think it's our best chance to get that order remanded. The second part was petitioners believe that
the FERC violated Federal Power Act Section 217. And I'd be more than happy to answer any questions, but I'll try to keep it brief. Essentially, that section of the Federal Power Act speaks to FTR markets and associated financial rights, returning the entire output of the delivered energy, the congestion revenues associated with that delivered energy, returning all of it back to load. So that was Section 2 of our brief. We outlined that. And then two of our other petitioners, ODEC and American Municipal Power, offered one additional argument to the court, which staff did not feel we could support. That was that the FERC erred in essentially rejecting PJM's application as to how to change the FTR market. So as I stated initially, it's staff's view that all FTR revenue should be returned to load. And some of our fellow petitioners felt that an incremental improvement in the FTR market would be the way to go. And staff did not join in that particular brief point. Just lastly, schedule moving forward so you know what to expect in the future. We're expecting the respondent brief of FERC on September 11th. And then several interveners did join the case in support of FERC. We're expecting their brief on October 2nd. We have a reply brief on November 1st, and then all parties' final briefs will be December 1st. In closing, I'd just like to report to the Commission that staff is working extremely well with other petitioners and are maximizing the value of this appeal by minimizing legal costs to the Commission and to staff and to the state to do our best to try and get the most value out of this appeal for the least money. You'll note that the entire 100-something page brief was attached to your agenda, and I would be more than happy to answer any small or large questions that you might have regarding that brief.
Thank you, Joe, and thank you and the rest of the staff for all of your work on this issue. It's much appreciated.
It's our pleasure, Commissioner.
Questions, anybody?
Mr. DeLosa, thank you very much. I appreciate that. Just send the check to my account at Delaware. I would also ask Mr. Farber to come up. Mr. Farber has been heavily involved in the shutdown of the Mid-Atlantic Power Pathway project and been working anxiously on settlement on several issues. So, John, I will pass the baton to you.
Thank you, Mr. Howitt. Chairman Winslow, Commissioners, good afternoon. This item is to seek approval of a staff recommendation regarding a form of settlement agreement in FERC docket ER 17-1016. As you may recall, this docket addressed PJM's filing of cost allocation regarding two projects for the abandoned MAP project, the Mid-Atlantic Power Pathway. And our involvement began when the Illinois Commerce Commission filed a protest to the allocation of cost on the basis that PJM had not demonstrated a benefit to the ComEd zone and filed for a different cost allocation on that basis. In our answer, we attempted to identify two previous settlements that, in staff's view, address the issue of the cost allocation that should apply to the MAP project. One of those settlements has been approved. The other is subject to rehearing. But staff took a position that the Illinois Commerce Commission should not have proposed a requirement that PJM demonstrate a benefit to the Commonwealth Edison zone on the basis of the flow of electricity, the DFACS, the distribution factor analysis, that shows where the electrons go, and that is the basis for the Illinois Commerce Commission determining the level of benefits. As a result of that, the docket was set for hearing and settlement procedures. I participated in those settlement procedures, and in order to seek a recommendation from the Commission, I would need to discuss confidential material and what occurred during these confidential negotiations, as well as a form of settlement agreement that still remains confidential. On that basis, I would request an executive session so that staff can provide the Commission this information.
May we have a motion requesting an executive session based upon the reasons stated by Mr. Farber?
A second.
Any discussion on the motion? All in favor signify aye.
Aye.
Any opposed? Any abstention? The Commission will go into executive session.